Welcome, everybody. I see a lot of you have coffee. I hope you're sufficiently caffeinated, but I don't think you'll need it for this session. I think it'll be a really interesting and important session. I'm Dan Werner. I've been representing immigrant workers in civil litigation for about 25 years, almost entirely with NGOs, starting here in Florida and then New York, and most recently, I was at the Southern Poverty Law Center for 12 years. A couple of years ago, I moved into private practice, and I continue to do pretty much the same cases, severe labor exploitation cases on behalf of immigrant workers. I'm joined by two brilliant movement colleagues, Adi Rico from the Fair Foods Standards Council and Eduardo Reyes Chavez from the Coalition of Immokalee Workers, and they'll speak more about their work. We're starting this session with the premise that policymakers and the judiciary are leaning harder in the direction of reduced accountability for violations of civil rights, workers' rights, and immigrant rights. At the same time, our country is seeing some of the greatest threats to the rule of law that we've seen in decades. So part of creating intentional solutions to human trafficking and other forms of labor exploitation is that we cannot count on courts exclusively to protect workers, and particularly immigrant and migrant workers. So human rights lawyers need to be proactive and creative. And there are still plenty of opportunities to achieve justice through worker-centered litigation. And at the same time, worker-driven and market-enforced solutions are what will ultimately lead to change. So we've posed 4 questions for this working group. In a nutshell, what does worker-centered litigation look like? How can we turn losses into wins? And how can forces that aren't as susceptible to anti-worker trends, worker mobilization and movements, serve as a catalyst for change? I'm going to start out talking about a particularly profound obstacle, forced arbitration, that I've been facing in several of my labor trafficking cases, and how we can kind of use this as an example of how to turn these obstacles into opportunities to kind of hold back this kind of anti-worker and anti-immigrant onslaught. So I'll start out talking about a case, or 2 cases I'm litigating in Louisiana. These are images of a cluttered shipyard in Cameron Parish, Louisiana. If you've never heard of it, it's because it's really in the middle of nowhere on the bayou. My client, Servando, worked here as a welder in 2019 and 2020. It's run down, it's fenced in, is, like I said, is far from anything other than some convenience stores that are still a long walk away. And the only way in and out is through a gate that is padlocked at night. According to the lawsuit, Servando lived in crowded quarters on a rusty barge that was sitting in mud, moored to the shipyard. Co-workers and his supervisors drank heavily. They also lived on this barge and would sometimes get into drunken brawls, and Servando was terrified for his safety almost every night. The work was incredibly dangerous. This is a picture that the defendants provided to show how safe their workplace is. Can anybody just see what the safety issue is with this picture? Any volunteers? All right. Anybody from OSHA here? All right. Yeah, he's wearing a harness. That's good. But what happens if he falls, right? The safety line is almost perpendicular. I mean, it goes straight out behind him. If he falls, he swings into the metal beams behind him and would get severely injured. So this is kind of an example. If this is what they're using to show how safe the work was, it gives you a sense of what the work really was like. So according to the lawsuit, if workers complained, the supervisor would yell and curse and threaten them with deportation. And so how does somebody from the Philippines end up at this shipyard? A Philippine Department of Labor agency called POEA runs a market for Filipinos hoping to work abroad. Ostensibly, this program is designed to protect the workers, but in reality, it entrenches a corrupt system that traps many workers in awful jobs with no means to escape and with practically no legal resource when their rights are not violated. So under the POEA program, foreign employers contract with manning agencies, that's what they're called, to hire Filipino workers. Under the agreement, the foreign employers agree to pay 80% of the workers' wages to the manning agency in the Philippines and 20% of the wages to the overseas worker. The worker then contracts with the manning agencies and through them with the employers. So the 80% of the wages that get paid to the manning agency takes money out for Filipino taxes and any debts the worker owes. And then the remainder theoretically goes to the workers' families. In Servando's case, he was contracted to work on a drilling vessel en route to the coast of Nigeria. That's what he was told. He entered the United States on a B-1 visa with an OCS designation. OCS is Outer Continental Shelf. So this is essentially a transit visa that allows workers to come into the United States, pass through the United States to go do work in the ocean, usually on rigs on the Outer Continental Shelf. If there are people from Homeland Security here, you may be familiar with this program. In reality, Servando worked on this moored, rusty vessel that wasn't even seaworthy. He estimated that it would take about a year from the point he left to when the vessel would even be able to go to sea. The defendants contradicted themselves. In a declaration, they described it as a new vessel. As you can see, it's not. And other documents they submitted show it was built in 1995, but then all vessels are registered. They have something called an IMO number. The vessel associated with IMO number was built in 1982. So lots of contradictions, lots of question marks. Sure. And Servando also worked in the yard itself. So again, he never went to sea. His visa was to go to sea. He never went to sea. When he was in the Philippines, before he came, he had to borrow money from the manning agency, and he could only pay off those debts by working in the United States. And the manning agency actually deducted, as I mentioned, those debts from the wages that were sent to the Philippines. So in short, Servando was living in substandard housing, doing dangerous work he wasn't contracted to do in violation of the terms of his visa, and he didn't have the financial wherewithal to leave. So he was trapped, he was stuck. So in September of last year, we filed this lawsuit. And in the amended complaint, we included these claims, including claims for labor trafficking, racketeering, wage violations, and torts. But little did we know that there was this convention that's kind of commonly referred to as the New York Convention that potentially would prevent Servando from obtaining any meaningful remedy for the violations of his rights. Based on this convention, the defendants filed a motion to dismiss Servando's case and to compel arbitration in the Philippines. Though Servando is in the US, the employers are in the US, and all the injuries happened in the US. So this is one of the contracts that the defendants claim Servando signed. This was for an extension of his work period. Of course, he couldn't have actually signed this particular contract because it would have been signed in the Philippines and he was actually in the United States on August 20th, 2019. So he rightfully claims that his signature was actually forged on this contract, but that didn't seem to matter ultimately. This was buried in the contracts. You look at this and you're like, what does it mean? I looked at this and also thought, what does this mean? I'm a lawyer. This is in English. Servando's first language is Tagalog. He speaks just enough English to be able to work on a ship as a welder. This meant nothing to him. But the defendant's claim is far from meaningless. And I'm not going to spend a lot of time connecting all the dots, but the defendants are arguing that this incorporates this. You can't read it? Yeah, it's pretty dense. Buried in this document, which is called the standard terms, on page 3 is section 29 that says that any claim or dispute arising from their employment is subject to arbitration in the Philippines in front of this body called the NLRC. So, English language document, something he never saw, compelling arbitration in the Philippines, the defendant's claim. We, of course, opposed the defendant's motion to compel arbitration for a lot of reasons, revolving around the formation and enforceability of the alleged agreement to arbitrate. And we also submitted an expert declaration from an internationally renowned dean of a law school in the Philippines. And he concluded in a nutshell that because of delays, endemic corruption, minuscule damages when they are awarded, and because the NLRC doesn't recognize US law, Servando would not achieve any relief for violations of US law if he had to arbitrate his case in the Philippines. So like I mentioned, defendants filed their motion, and the court issued a report and recommendation granting their motion. My client had no right to access the courts in the United States for the injuries he suffered here, for the labor trafficking he alleges he suffered here. He could only bring his claim in the Philippines. We filed extensive objections to the magistrate judge's ruling. The district court upheld it without any analysis. I have the number of pages because I'm still a little bitter because we put a lot of work into our objections. Without any analysis, upheld the magistrate judge's ruling, and we're now appealing this to the Fifth Circuit, where the odds aren't good for us. The last case I'll just briefly mention is a case on behalf of janitorial workers who were duped into purchasing cleaning franchises that left them and their families mired in debt, often earning sub-minimum wages and with no way out. Based on the alleged franchise agreement, or buried in the alleged franchise agreement, was an arbitration clause. So defendants moved to compel arbitration, this time in the United States. And in this case, as well as in the Filipino worker cases that I discussed, the contract that had the arbitration language was one of the instrumentalities of the forced labor. But it is still, the courts are still determining that these cases are subject to arbitration. So in the janitorial case, the court granted the defendant's motion to compel arbitration. Again, there are forced labor claims in that case, and we're appealing that to the Ninth Circuit U.S. Court of Appeals. So even if we lose, as creative as we try to be, we face an uphill battle. What would victories be in these cases? First, the litigation itself has served as a catalyst for the workers who escaped to remain united, together, and organized. Secondly, and relatedly, It's appalling, of course, that the workers subjected to these horrendous violations of their rights, and as outrageous as it may be to those in this room, imagine how outrageous it is to the workers themselves. They're together in their outrage, and they're organized to speak out. And they will do so. This will be public, and it will be noticed. And noticed for what? There's obviously a value in shaming employers, and a value to bringing hope to people who are still trapped there. But it also brings me to the next question, which is, what legislative solutions are there? And I'm going to kind of wrap up with a little pitch. So even in the US, and this isn't even factoring in foreign arbitration, according to the Economic Policy Institute study, workers were 59% more likely to have successful outcomes in litigation as opposed to arbitration. In another report by the American Association for Justice that looked at a 5-year period, only 2.5% of employment cases brought to arbitration resulted in an employee award. This is also, not to mention that arbitration is confidential. So one of the impacts of litigation is that it is public and, hopefully will change behavior of other companies. Arbitration is confidential. You can't take discovery from non-party witnesses. And there's practically no right to appeal an arbitrator's decision. Even if they are totally wrong on the law, the Supreme Court has said that you cannot appeal that decision to a court. So I'm aware of 7 labor trafficking lawsuits or human trafficking lawsuits that have been forced into arbitration. And one solution is piggybacking on a law that was passed just a few months ago called the Ending Forced Arbitration and Sexual Assault and Harassment Act, adding essentially 3 words to it. So excluding not just sexual harassment and sexual assault, but also adding human trafficking, excluding human trafficking claims from forced arbitration. It's a very easy fix. It's starting to get a little traction in Congress. And I would love y'all to pick up the ball on this. I'll be pushing this more, and I'll be pushing this aggressively, as will networks and organizations that I'm affiliated with. And this is a very important solution that would prevent these kinds of problems from happening. But in the face of ever-increasing impediments to workers' abilities to access justice in court, there are answers outside the limited tools the law offers, which leads us to the next 2 questions and to Gerardo.
Can you hear me clearly? Very well. Well, after we heard, of some of the things that go on for workers in different settings, I would like to just mention, something that's really important for what we're gonna describe here. We're gonna talk a little bit about what we do to fight against human trafficking in cases of modern day slavery in regards to agriculture, right? One of the things that I want to mention, it's that the law, from what we understand as workers, is reactive. It responds to problems that have already occurred. It responds to people whose lives have already been marked forever, especially when they go through situations of modern day slavery. So let's not forget that. The law responds to problems after they happen. What we're going to talk about, it's an approach that is proactive towards identifying and even preventing these abuses. So we're going to talk a little bit about that. But first, thank you for inviting us. I'm Gerardo Reyes with the Coalition of Immokalee Workers. I have been doing this work for about 23 years. Our organization is a human rights organization fighting to improve wages and working conditions. It didn't start as an organization fighting human trafficking, but it came about. Workers will come and talk to us about what was going on. The reason why I got involved with the coalition is because in 1999, when I arrived, there was a situation where a crew leader didn't pay us for the work we did. So we ended up homeless, jobless, moneyless, all in the same week. That forced us to look for a job desperately. 3 a.m., we were waking up, just looking for anybody that would hire us. We didn't know anyone in town. There, we were able to find a job. And this guy was the connection between workers on the Cuello case. That was one case that happened, was resolved the year before I arrived. And I met these workers, they became my friends. And they told me how they were sold. They were bought and sold on the side of the street. $5,000 were imposed on them. And that was my introduction, to Immokalee. Wage theft, abuses that had no solution sometimes, and situations of modern slavery that were affecting other workers. That was the beginning of my story. So to talk about the problem, this is not something that just happened to us as a little group of people. This is something that happens everywhere. And we have seen how many newspapers have talked about this, and yet we continue to see these cases emerge. So we need to ask, why? Why is it that since the coalition started until just a few years ago, there were 9 cases that were uncovered, investigated, resolved. More than 1,200 workers that were freed from these conditions. In some of these cases, we had to go to work undercover and get the evidence for the FBI and the different police forces that were involved in all of this work. And there's nothing romantic about it. There's nothing like heroic about having to do things like that to save people from these horrible conditions. So I also want you to understand that. We have done this job trying to fight against this problem that doesn't exist in a vacuum. That's another thing. Slavery doesn't happen just because one day somebody decides, oh, I'm going to force these people to work against their will, right? Slavery happens because there is an imbalance of power between workers and their employers, and because there's a lack of oversight, especially now. And I'm going to get a little bit into that in a second. I just forgot to put my timer. So I'm going to ask Artie to remind me when I'm at my point. But what I want to say is that when you live in a reality, and this is part of the context, when I say slavery doesn't happen in a vacuum, it happens because the conditions allows it to happen, and there's nobody to look at these problems. We live in a reality where, as workers, we were receiving 40 to 45 cents per a 32-pound bucket of tomatoes. That was the same wage for more than 3 decades. Now, there's not many places where you can say like, oh yeah, these workers are receiving the same wages for that amount of time. We live in poverty. Because of that, workers are afraid of speaking up. Because of that, workers are very vulnerable. Because you cannot risk your ability to go to work. So many abuses happen, and you have to basically keep quiet if you want to keep the food on the table for your kids. All of this is what creates the environment for these cases to emerge. And that's why we have seen one case after another. There are situations of sexual harassment and sexual assault. There's been situations of violence in the fields, and that's like the norm. That's not like, we're not talking about the extreme. So if the norm is so backwards, then the extreme is not too far. And that's why we see these cases emerging more and more. Now with H-2A, there was fear in the industry because of the policies that were being pushed, against immigrant communities. And that fear led to a change that is now representing more and more workers under H-2A that come without any kind of oversight. Same problem. Now, the argument that, oh, this happens to workers because they have no documents. Oh, there's a mix of cases. It has happened to workers that have visas, that have been here under political asylum, that have no documents. But the problem and the moment in which we are now with H-2A workers is that it doesn't really matter if you have or don't have documents. We have seen how these cases continue to happen. In Georgia, there was this case that involved 71,000 workers. They were forced to work, being paid ridiculous amounts they were being paid cents, I think 25 cents or something like that, for every bucket that they were forced to dig out of onions, in Georgia. This operation or this case started for us in 2015. There were, workers that were telling us that they were afraid, that they wanted to see what could be done, and told us a lot of things about this case. And then eventually we had enough evidence to be able to work, and bring it to justice and do our part. 71,000 workers in the span of just a few years by a group of 24 delinquents, I should say, criminals. This criminal organization forced them to work, to pay $2,200 more or less in fees when they were hired in Mexico. That was enforced with threats of death. 2 workers died that we know of these 71,000. There's, I'm sure, more to this story that is unknown. But 2 workers died because they were pushed to work until their death because of extreme heat. They were forced to work for free to pay the debt, and all of them were threatened. We help some workers, we assist them in trying to find a job, in trying to start over. But what we see here is what I was saying at the beginning. We need to be aware that law doesn't necessarily resolve the issue that we're talking about, which is we need to change the context. We need to work to improve the working conditions of workers in the fields, to be able to then land, these ideas. There's a lot of confusion. There's a lot of conversations that are happening right now. What we are saying with our work is that there's a solution that came out from the workers themselves. We created the code that basically it's a legally binding agreement. When we started with this campaign, when I arrived in 1999, we started to talk about how to bring this industry to the table, how to change the conditions and eliminate, the modern day slavery that's going on from this industry. And we realized that we can't unless we have the forces that give this industry the money, the power. And those forces were the market. So in 2001, we started with Taco Bell. We were absolutely alone. There was just our community. People thought that we were crazy going after Taco Bell, going after the market, and asked them to sign agreements where they would commit to zero tolerance policies for modern day slavery. That was the beginning. That increased to include sexual assault and child labor. And when we started with this, we were aiming to bring the power that had the influence to then set the standards in the agricultural industry to change the conditions. And we started with Taco Bell, then McDonald's, Burger King, Subway, Whole Foods. In total, there's 14 corporations, including Walmart. And they have signed on to what we call the Fair Food Program. Now, the Fair Food Program is a collaboration between workers, growers, and retailers, the brands that I mentioned. And the goal here is to guarantee that workers are receiving a bonus that comes from these retailers that, and I'm going to talk a little bit more about details on that. But this is basically the idea that we were pursuing. If we bring the buyers to work with us and sign legally binding agreements and use their buying power and cut purchase if necessary, when workers are demanding a solution to their problem, or when problems that are zero tolerance happen, that they have to cut purchases. And that worked. Since we started with the campaign for fair food until 2011, we got several agreements and we got the growers to the table. When that happened, we were basically able to land the protections that I was mentioning. Workers, for example, they receive a booklet under a session of education. They know what's going on. They are the most important part of everything. So workers use the system to complain about the problems they see. And then when they complain, there is a resolution that takes place. There is an investigation that's done by the Fair Food Standards Council that is brought to a point of resolution. And if the problem impacts a few workers, if the problem impacts an entire crew, then the solution is going to be adequate to the problem, right? We educate workers, then they use the system. In this example that you see here, we use drawings, we use different things to educate workers about sexual harassment, for example. And all of this process of education incorporates the call for help for workers to help us identify where things are happening, where situations of modern day slavery might be occurring, that they hear, that they know of. In these sessions of education, workers have the ability to talk about the things that don't work for them. Then we go in, the Fair Food Standards Council go in, that it's something that gets resolved. And, you know, since the starting of the implementation of the program in 2011 until now, there's been many complaints that have taken place, 3,500 more or less, and Ari can correct me. But there's more than 10,000 problems that have been resolved. And there hasn't been, you know, any of the situations that we've seen in terms of modern day slavery, the investigations, everything that we've done. Inside the program, there's zero tolerance. So whenever there's something that happened and it was tested and it worked, in less than a month, a case was resolved. Now, and everything, you know, that we needed to do was investigated and resolved, as opposed to the cases that I mentioned, you know, the case, the Blooming Onion case in Georgia that took several years, since 2015 until last year in November. I mean, all of these years were years that people were giving up their dignity. And we need to make sure that we aim for prevention, not just to respond to what has or is happening right now. And for that, I think that we need to be able to understand that we have a lot of things in common that we could be working together with. And that one of them is recognizing the workers are the creators, the architects of something that actually works, that elevates and doesn't see law as a limit, but as a floor. Because on top of the law, we as workers have created provisions and protections in the fields. We have moving shades structures. That's part of what we have. We have the right to form committees on health and safety and talk about not just how to prevent accidents, but also how to improve the environment in the place of work, how to eliminate situations that make people uncomfortable, sexual harassment, things that create a hostile environment. That's where we are. And when you have a community that knows their rights, a community that understands that there are protections that were created for them, they use the system, and that's what made it work. And we are very, very happy to say that this is something that is expanding. I'm gonna make a pause right here. because there's a little bit more on that, the expansion part. But what I would say for now, it is an honor for us to be here. And I really hope that this conversation doesn't just stay here. I really hope that all of you do your part to try to connect with the immokalee workers, the Fair Food Standards Council, with Dan, and try to think, a different path, because there's no need to reinvent the wheel. There's something that works. Just get close to it. Let's work together. Thank you.
Hi, good morning. Now we're going to dive deeper into what makes the Fair Food Program so uniquely effective. But first, let me reintroduce myself. My name is Ariadna, or Ari Rico, and I have the honor of working for the Fair Food Standards Council, or FFSC. The Fair Food Standards Council is a third-party, separate nonprofit organization that is responsible for monitoring the agreements that the CIW signed with both the participating growers and the participating buyers. And we do that through a selection of very effective monitoring mechanisms. And one of the most powerful ones are our rigorous audits. So what that means is that because we cover 90% of the fresh tomatoes in the state of Florida, we spend the majority of the year auditing all of the participating farms in Florida. But some of the growers that participate in the program are actually big companies, big 500 companies, Fortune 500 companies. So they have a lot of operations. We also have very small growers that are just like an owner, manager, one farm kind of operation, but we visit all of them once per season. And our audit team has unprecedented access to the growers' records, to interviews with upper management, with all field level supervisors that interact with workers. And we aim, at the very least, but sometimes it's more, to speak with 50% of the workers that are present on the day that we're there auditing them. We also do housing visits. We monitor transportation. We interview workers in buses, and it is truly a rigorous and comprehensive process. After the visit, the team also completes a payroll audit, and that means that growers provide their records to us, and we're able to monitor for a variety of wage-related provisions in the Code of Conduct, but that can include all H-2A regulations, since the workforce now in their majority is H-2A workers, but also the distribution of the Fair Food Program premium, which is provided from the participating buyers directly to the workers themselves in a separate line item in their paychecks. We monitor all that, and I'm going to speak a little bit more to that success in a little bit. After the audit is completed, we provide the growers with a report of all the findings of either compliance or non-compliance. If there's anything that is found to be an urgent non-compliance, then the grower can be put in probation, and then the audit team goes back until those findings are either corroborated or they're brought back to compliance. And there's also a process that is binding. We provide growers with a corrective action plan on how to become compliant in the Fair Food Program and avoid probation or suspension in the program, which means that they cannot sell their produce, right? So these caps are what forms the basis of our next round of audits, right? We also travel out of state, all up the East Coast, but I'll show you a map or where the Fair Food Program monitors the growers. The caps form the basis, so we don't start anew every time that we're there, right? We're also becoming experts in the industry, experts in each grower's operations, their systems. So we have a pretty vigorous database that has been informed from the 11 years that the Fair Food program has been doing this kind of work. The next mechanism, it's, I think, a really critical one, because we can all agree that an audit is just an audit, right? It's just a snapshot of one single day when we were there, everybody's in their best behavior. So our complaint line is basically our live feed of what's going on in farms when we're not there. And that's when the work of the CIW, when they go in to provide those worker-to-worker sessions, is so vital, because then workers understand how to redress the issues, right? Like what mechanisms to use to call the hotline, to create that trust, to know that there is a way to report issues, or if they only have a question, that is fine too. The hotline is answered 24/7 by the same multilingual investigators that are out there speaking to workers, knowing these systems, experts at who is out there, what characters are embedded in the everyday lives of workers. And this is so important, because for H-2A workers or a migrant worker that is maybe on their first day at a farm, they don't know where they are. It's the first time in the United States, maybe in Georgia, in Tennessee. They don't know who their supervisor is, what their name is, and they just know them by a nickname. That's why our knowledge, our expertise comes in handy, because we can triangulate that information and know where the problem is happening and try to address it with the worker. I would like to highlight that compared to the litigation mechanism, our complaint hotline is extremely effective. We resolved all complaints, 65% of our complaints in less than 2 weeks, and 82% in less than a month. That is lightning speed, and so important, because we know that justice delayed is justice denied, especially when a worker is back home in their country, in a rural area, because their contract ended. We need to work fast, and we need to work effectively. Like Gerardo mentioned, it has been over 3,600 complaints. That means that in 11 years, we have averaged one complaint that actually gets uploaded into our database and gets taken through its resolution or conclusion. And I make that distinction between a resolution can be the solution to the problem, but we also have complaints that are not valid after investigation, right? So we are very aware of that. We are the impartial organization that does this work. We do have questions on the hotline that don't get necessarily uploaded. So it's one complaint a day that we've been taking for 11 years. We answer it live, whether we're in the shower, sleeping, we answer it. And it's so important because workers work so early, come back home to housing really late. So we need to be available. And at the beginning of the program, it was so necessary to ensure protection from retaliation, right? Just because you can use a complaint line and report your problem doesn't mean that the next day your boss is not going to find out and try to fire you. So redressing any retaliation was so critical, and it continues to be, as well as trying to maintain confidentiality when we can. Obviously, some complaints do require the identity of the worker for wage reasons, but if we can, we maintain confidentiality as much as possible. Now, to the teeth of the program. This is truly what makes it work. We are very good at what we do. And I keep looking that way because I'm here with my colleague, an awesome investigator, probably the best. And we take great pride in what we do. We love what we do. We're really good at it. But if you remember anything from today, I hope that it is that standards without enforcement are just standards. We need the market enforced consequences to make it work. That means that the Fair Food program makes doing the right thing good for business. It means that if a grower is found to be doing a zero tolerance provision on the code of conduct, then you cannot sell your produce. And that really incentivizes compliance. And that's how you get them. And we do consider participating growers as our partners. We sit at the table with them. We negotiate corrective actions with them. We take their points of view in consideration. We truly do. But without this, I don't think that they would be as willing to listen to our suggestions or corrective actions. It's truly what makes it happen. And it's from these participating buyers that they could not sell their produce to. I would like to note that the case that Gerardo mentioned, there has been one forced labor case that came through the hotline. And it happened because the prevention requirement of checking the supervisor ineligibility list in the Fair Food Standards Council website was not followed through. So the perpetrator was hired, but the other monitoring mechanisms worked as they were designed to work. The complainants called the hotline. Investigators were out there in less than 24 hours, interviews were completed and arrests were made in a month. And this all led to a successful prosecution of the perpetrators. The grower was put in probation and the audit team went back as many times as it took to make sure that compliance was being done. Seeing all these results obviously create that trust in the workers too, right? So the system, the way that the program was designed it's because workers' voices have been embedded from the beginning. The code of conduct is not a generic code of conduct. It is a code of conduct that is based on the experiences of workers, because workers are ultimately the experts in knowing how, by when and by whom their rights are being violated, right? So the success of the program in the 11 years has been unprecedented. From the early years, the worst characters were banned from Fair Food Program participating farms. Sexual assault, forced labor, violence against workers have been virtually eliminated. And systematic wage theft does not happen basically in the farms that we audit. 3,600 complaints, one a day, have been resolved, and over $40 million have been given to workers in their paychecks as a separate line item in the Fair Food Program premium. We monitor all that as well. 77,000 workers have been educated on their rights in these CIW worker-to-worker education sessions, and that empowers them. But the results of the program give them the trust to continue using those monitoring systems, right? To continue trusting us when we're out there in the field, they're working. We do acknowledge that it's without the consequences, it wouldn't be happening. Health and safety committees have been formed, and that gives workers a voice with management to sit down and talk about what they're seeing out there in the field that can be a danger to them, that is unsafe. Heat stress protocols have been implemented, mandatory breaks, shades, drinking water accessible, all that is monitored as well. And the results are win-win-win. Workers' rights are obviously being protected, but growers also become employers of choice. They have less turnover in their workforce because workers recognize that they're an employer that is trying to protect their rights, their well-being, and obviously they also receive purchasing preference from participating buyers. That does not hurt. They improve on their management systems and they avoid litigation because there is a risk prevention that is happening that is very dedicated because it's in the code of conduct and the design of it. And for buyers, in an era where consumers are so concerned and aware of where their food is coming from, they also can say, we have transparency in our supply chain. We know where this tomato is coming from, this cut flour is coming from, and it's win-win-win. This is what the Fair Food Program covers in their audits. I am happy to say that in a couple of weeks, we will be going to Colorado to do some entry audits in different crops. Once successful completion of the entry audit happens, which we're hoping, then Colorado will be light up in that map. So we cover different crops, fresh cut flowers, and 90% of the fresh cut tomatoes in the whole United States comes from Florida. So it's a big industry. And I'll take it back to Gerardo for all the recognition of the Fair Food Program.
We almost get to the very exciting part of, questions and all of that. But before we get to that, I want to, just mention a few things. You can see here that there's been attention placed on the work that we've been doing. There's some recognitions. You see the MacArthur Foundation, they recognize one of our members. And those were, some of the statements. The Harvard Business Review, that's very important. They have done studies about social impact, and the Fair Food Program and what we call the WSR model, or worker-driven social responsibility model, which emerges out of the experiences of the implementation of the program, really. When we think about all of this, this has been recognized as one of the 15 most important social impact stories of the past century, including, the change of wearing seatbelts in terms of how many lives it saves, and many other things. So this is a beautiful thing that is happening today here in the US. And this is what we were talking about, Our stories doesn't have to be stories of suffering. We can end it. We just need to be able to see it, recognize it for what it is, and work, support to implement all of this. Oh, wow. Sorry, City. Oh, wow. Anyways, as technology advances, I would like to just say, that in terms of the things that we have been able to achieve, we started first in Florida, and that's the part that I wanted to highlight. We moved out to other states because of the buying power of Walmart. 2011, Florida, 2014, Georgia, the Carolinas, New Jersey. Just to give you a few examples, we recently expanded to Tennessee. You saw the map, different crops and all. But outside of it, there's also, realities for poultry workers, for dairy workers, the fisheries, the garment industry, where we are working very close to them. And we have expanded, and this is where we refer to it as the model, WSR, worker-driven social responsibility. We expanded to the state of Vermont. Migrant justice, dairy workers started to follow us, to shadow us in the process of campaigning to bring the market power to be part of the solution on how we created the sessions of education, the process, the booklet, everything. And from there, they were able to land these with our support. That's what we are doing. We're supporting different groups that are genuinely trying to land this. So the dairy industry is the first replication of the Fair Food Program, of the model. Outside of it, we are in conversation with workers from the fishery industry. And we have heard some of the predicaments that they go through. That sometimes they go to the sea for about a year without seeing anybody else, without protections, and depending completely on their boss, really. They are looking for this solution, the WSR. In Bangladesh, we are applying some of the provisions we created to protect workers in the fields. In regards to health and safety, that's one of the most important aspects of what they adapted in terms of the model, because of the fires, the collapsing of buildings. I don't know if you remember, but there were more than 1,000 workers who died in the building that collapsed. And that could have been avoided if this model was already there. So that's why this is so urgent. It's a matter of life and death for people that have no choice. So Bangladesh, it's applying this. In Lesotho, same thing. And for us, when we think about this, and when we think about how it was before we started any of this, our wages stolen, our friends being kept hostage under threats of death, and a fight that has lasted more than 3 decades that has brought us to this point. This is just the opportunity that we wanted to share. The future, is not written in stone. When we started, people say, you will never succeed. How do you imagine that a group of 30 workers from a forgotten town in Southwest Florida is going to be able to challenge Taco Bell, which was part of John Brands? John Brands being the largest conglomerate of fast food in the planet. It was impossible, many said. But yet we did it. And we did it because we needed to do that, because our dignity is worth that and more. Because our freedom, while we're feeding the country, shouldn't be at risk. It should be protected. And that's what it is. Now, sometimes the message gets lost in who the messenger is. Because we as a community sometimes are casted as the ones that don't have a voice, the ones that don't have a clue what's going on, the ones that need saving. And I'm here to tell you that that's absolutely wrong. We have a plan. We just need the support, the recognition, and the work together to make it happen. So thank you very much.
Thank you. First off, I want to applaud you, Gerardo and Ariana. I've called multiple speakers, but I'm super ecstatic at the fact that you started, like you said, with just approaching one business, one corporation, and in such little time in the grand scheme of things, you guys have been very effective. And like you said, you had what, 65% resolution, and then within a month's time, 90 something. That's impressive stats anywhere in any organization. So again, I applaud you, and I hope everyone applauds you. I have a couple of questions. I normally have several questions, but I try to keep it short. I work for U.S. Customs and Border Protection. I interviewed our unit, our team. You interview several H-2A visa holders coming into our ports of entries, and we have seen things that can be from labor exploitation to possible labor trafficking. I'm curious to see. Our challenge is we have the first step, but then we see that when it gets to maybe the litigation level, it doesn't meet certain thresholds for them to bring it up to go for prosecution, right? Or maybe it's just only exploitation or whatnot. I had not heard of your organization. I will be reaching out to you after this, of maybe trying to get some of these things resolved for these workers. We noticed that there is exploitation, and we don't see the litigation following through. I was wondering, with the cases that you do take to litigation, what percentage of all the ones that you have that actually go to court, and what percentage do you win with that? So that's my first question, if you can answer that.
There we go. So before we go into litigation, I can let Dan and Gerardo speak to that. I mean, there's a lot that we cover in the Fair Food program. We do monitor. So for the participating growers that use the H-2A workers, we monitor all of their ETA 790s, that is the petitions of all the workers. We all the contract review that happens in the consular city because workers come, we review, results of contract for workers to see if they were going to be brought back to the same grower, for what reason they're not going to be brought back. And I think most importantly, because it is. Hello, there it is. Because it is a recruitment system that is so embedded in fraud. We do see some extortion fees to just even be recruited for the opportunity to come and work here in the United States. But we have an agreement with SNE or the National Service Employment Agency in Mexico. That is our sole recruitment system to bring workers without any fees. So the workers that are in Fair Food Program farms should not have paid extortion fees, have known their contract terms before coming, know where they're going to be. But it is something that these workers then end up in other contracts, right? And then we don't have the same protections for them in farms that are outside of the program. But I'll let you speak to maybe the Blooming Onion case or any other cases you have worked in with H2A.
Well, I would say that before we had the program, the answer has to, the question has two answers. Before the program, we had to investigate every lead, everything. And it was actually a fight to be able to have the attention of authorities. Some of my colleagues went many times, with archives, with investigations, and they couldn't find an ear on the other end. That has changed because we have created something that is so effective and has been recognized that it actually had impact on the protections it offers or that takes place for workers on their human trafficking circumstances because of the work we did, the visas and many other changes. But it was always, just following for years many of these situations. The difference with the Fair Food Program is that we were able to, in all of these years, connect to help to co-found also different structures like the Freedom Network, for example, or many others that work to push, against all of these crimes. So along with that, and also everything that we've done in bringing those cases to light has changed the conversation about this. So I think that we have a complete different reality right now. And what we need is just to focus on how to expand what works to the places where it is not being applied yet. Because again, this case would have been resolved if in 2015, when we first heard about it, that those farms were part of the program, it would have been resolved like that. None of those instances of abuse, the people who died, all of it could have been avoided. That's the preventing nature of what we're talking about here. And I think that it's gonna continue to be the same outside where there's no program, where we are not recognized as a leader in anything by those who are exploiting the workers, or there's a lack of action on the part of authorities when needed. We have changed all of that. So I think it's never gonna be the same, but it's always gonna be a challenge outside of the program. If we were to bring a few more buyers to the table, like Wendy's, for example, if they were to join, we have invited them and a few others. And we get to a point in which we have a group that's big enough to influence the rest of the market. Imagine if with 20% of the market, we have been able to do this, to expand to 7, 8, 9 states now and other countries. Imagine what we could do if that was an understanding that every consumer every enforcement agency, every organization of human rights understood and embraced. And if we were able to land this everywhere, or there's agriculture in the US, the implications of it would be huge. So, yeah.
As to litigation, I think that's a really great question. And from the perspective of law enforcement, I imagine it must be really frustrating, right? Because law enforcement, only a very small percentage of cases that are human trafficking cases end up getting prosecuted. And I imagine those of you who are on the front lines see a lot of cases that you're like, wait, what happened with this, right? And I think there are a number of reasons for that. I think it's getting better in the labor trafficking, in the fight against labor trafficking. Operation Blooming Onion is an excellent example of where law enforcement and the U.S. Attorney's Office being proactive and actually taking very affirmative, important steps to address the severe labor exploitation in the fields in Georgia. And I'm working on a case in New Jersey that's also involved law enforcement, very complex investigation. But the reality is that, as you know, criminal prosecutors have to prove their case beyond a reasonable doubt, right? In a way, as a civil litigator, I had the luxury of just having to prove my case 51%, preponderance of the evidence, more likely than not. So that means that there's a large gap between what law enforcement is able to do and what we as civil litigators are able to achieve through our cases. And one example is a case I worked on in Louisiana when I was at the Southern Poverty Law Center on behalf of also ship and rig repair workers, seems to be a theme in my career, and labor trafficking. Law enforcement really didn't touch it. The Justice Department didn't prosecute. We ended up with after years of litigation and a 5.5-week jury trial, ended up with a $14 million verdict just for the first 5 people to go to trial. And then ultimately a $20 to $22 million settlement of the case for all the workers. To the point that's been made, that case was filed in 2008 and didn't go to trial until 2015. Those workers, it took a lot of perseverance to sort of stick with this process for the duration of the litigation, and where a program, something like the Fair Food Program and the work that the Coalition of Immokalee Workers does, is, you're talking about weeks or maybe months to reach resolution, and so it's a much more efficient program. But going back to litigation, we have to get to court. Right. And that's why I kind of highlighted these cases, is that this is forcing these cases into the shadows through mechanisms like forced arbitration means that these cases will never come to light. And it's becoming kind of a growing trend. Have not seen it as much in the H2 programs, but we're seeing it more and more across all sectors of labor, that cases are being forced into this secretive arbitration process where outcomes just aren't, what they should be. And I should say also in arbitration, you can't bring class actions, right? So, or you usually can't bring class actions. So that's a really important tool to be able to change employers' behavior, where if one person sues at a time, the employer will just kind of get rid of that case. But if all the workers go to court and bring a class action, that's what's going to ultimately change their behavior. Arbitration prevents that. So this is, one of the battles I've chosen to fight. It may be a losing battle, but I'm committed to it. And
my second question and last question is, our team, again, doing our research, and we have found that approximately 20%, give or take, from the last statistics that we saw, are responsible for subcontractors or contractors are responsible for the 20% of the all H-2A visas that are issued are given to those people, but yet they're responsible for over 55% of all violations. And even following up with Department of Labor and whatnot, you see some of these companies get fined or debarred, but then the debarment is only 5 years long. And maybe I have a company as a subcontractor under my name, you fine me, you debar me, I just tell him, hey, create a subcontract, and then they still outsource those workers to those farms or those, warehouses, et cetera. So how are we addressing those loopholes? How are you guys as an agency trying to address that? Or are you working close with Department of Labor or Department of State, who issues the visas? How are you working with those other federal organizations to try to address these issues, these problems?
I mean, it does feel like playing whack-a-mole, right? We do, part of the audit process is to speak to all of these crew leaders, to know their practices, and I mean, know it from their mouths, but also know it from the workers that they're supervising directly. If somebody is found, obviously, to be a problematic character, we inform the grower, the employer of this person and let them know. I mean, does that prevent them from going outside to a not participating farm and recruiting workers and filing a petition? No, it doesn't. But at least they're in a radar and they're not able to work at participating farms. And we can try to, prevent, from workers. If we know that this is a problem, we get texts all the time from workers that are back home in Mexico, and they're like, I have this contract possibility with this person. Have you ever heard of them? Do you see any issues here? And we advise them and we say, this is fraud. This is not legitimate. But we do have a close relationship with some DOL members that we do provide cases that we cannot do anything with to them. But there is a lack of oversight. There isn't enough because there's so many petitions, right? And it is becoming kind of like this Band-Aid on a bullet wound, and people have so much faith in the H-2A program because there's such labor shortages, so they rely on it. It's how it's being painted as this solution to all the problems, but it does present a lot of risk for workers.
I would say, following the metaphor, it's not a Band-Aid on a wound, it's a Band-Aid on a bleeding wound. Because the case that we are referring to, the blooming onion in Georgia, is not the only case. There's other cases that we are investigating as we speak. Obviously, you understand why we cannot talk about them, but there's at least 2 cases that we are, investigating. And just to think about why, this is happening. If people are, what I was saying earlier, like, it's not a matter of documents or not. When you think about it, really, it's a matter of an industry that exploits whomever is available in the absence of mechanisms to protect workers. That's what it is. So again, I would just highlight, we are doing everything we can to expand these, and whatever we're able to land expansion, like in Colorado, there's conversations going on over there, and that's very exciting. And there's interest from so many different sectors also. This is something that we need to expand, because the visa program in our context is actually a blessing for workers, because everything that's stated in their contract is the law. And under our agreements, because of the market consequences that are worth millions, and that's important to note, the difference between a complaint that goes through court versus a complaint that is enforced through the market and then to court, because all of these cases are not absent of the legal component. It is necessary, and we collaborate, we work with authorities in everything that we have to. And but we need to, we need to be able to just expand these more and to be able to also have more of these conversations across the country. The narratives are just lost sometimes. Many corporations are talking about social responsibility, and they are failing horribly because they are treating these issues as if they are PR. When problems of human rights and human dignity, people dying in fields, is not a PR issue. And we should push back against that whenever we can. So
Yeah, it takes getting creative, right? And I think, the coalition of the Immokalee Workers Fair Food Campaign are sort of the quintessential sort of, these are creative solutions that have brought results. In my sort of very narrow world of litigation, just one example of something that we did in Georgia in a case I was collaborating with Georgia Legal Services on, a farm labor contractor who, sexual harassment, massive wage violations. I was browsing the Georgia statutes because I'm geeky and I do that kind of thing. And I found something called a laborer's lien. And I did some research. It's something that hadn't been used since like the 1960s, but it allows a worker who is owed money to put a lien on the employer's property. And we said, well, this hasn't been used in 50 years, but let's go ahead and try it. And we filed laborer's liens. We also brought Georgia RICO claims, racketeering claims. The Georgia state racketeering RICO law has very powerful injunctive relief provisions that essentially allow you to force somebody to abandon their business. They can't practice their business anymore. And the combination of those two factors led to a really quick settlement of the case. And so that was kind of trying to, okay, this case may drag on for years. It's gonna take a lot of resources. What is it that's really gonna push this contractor to change practices? And ultimately those creative solutions worked in this particular case.
Just real quick, I recently had an investigation involving a miner. The miner was picking tomatoes here in Florida, and $5 a day, 16 hours workday. Working with ice and all these different kind of things. How do you know what farms are with fair food? How would we know that?
that was my mistake.
Yeah. No, I saw that. Is that on on a website? Because the miner was going between Immokalee and Lake County, being sent between the two different seasons, different times. So if I should find out that miner was at one of these farms that are with you guys, can someone outside of a worker call that hotline?
Absolutely.
Okay.
Yes. And we should have brought the phone number. Yeah.
Is it on your website?
It's
in the book? In the
it's
website?
not in the website. Is it? No. Do you have a card, Jenna? Yes.
I can write it down
Jenna
afterwards.
saving the
I'll grab you.
day.
Oh, no, Jenna didn't say that.
Let's take them down.
I'm trying to find the KOR booklet to see. Oh, it's not, of course not. I can get it to you.
Perfect.
I have a picture of it.
Perfect. And
Yes.
perfect. And last thing is, you put up the picture of the businesses,
Yeah.
that are a part of that. What can we do as collectively as, we all have our own resources behind us? There should be more. There should be more. So what can we do to help advocate that these businesses step up and do what
Expand.
is necessary?
Boycott Wendy's. That's the first thing on the list if you want something to do. There is a ton of materials on our website, so anybody can participate on this campaign, which aims to bring Wendy's to bring the farms where they are buying from, the greenhouses. They claim that it is about quality that they move, but the reality is that they moved out of Florida, punishing their own growers because their growers were implementing the Fair Food Program. In other words, Wendy's punished their growers for respecting the human rights of workers and implementing a system that eliminates modern day slavery. And what did they do? Went to Mexico, buy from Bioparques de Occidente, which is a mega farm in the state of Jalisco, where close to 300 workers a year and a half before Wendy's moved to buy from them were forced to work under threats of death on a horrible case of modern slavery. Workers didn't have beds. They slept in pallets, basically. They had no windows. Bathrooms had no running water sometimes. There were families with kids. They had to engineer a way of cooking their foods outside with pieces of wood and cinder blocks. I mean, that's horrible. And I'm sharing this because that's the reason why we declared the boycott. Because no corporation should, for many years, take advantage and make profit of the suffering of workers that are trying to change the conditions. And when they finally are able to change some conditions, then they punish the growers for doing just that. That's just wrong. So boycott Wendy's. That's the reason why. And stand with us when we are calling for other corporations to join, like Kroger. But also, I imagine that there might be a connect here with the White House or something, where you might be able to talk to the State Department or any of those departments that consume a lot of food and ask them, what's up? Are you buying? Like, can we direct somehow our efforts to support these workers? Because they are doing the job that we are supposed to.
And call your representatives in Congress and tell them that labor trafficking or human trafficking shouldn't be forced into arbitration, and that survivors need to be able to access courts. A small action item, but we need help.
And to my regret, there is no more questions. Because here I saw 3-4 hands. Who am I to choose whose question is more valid? So we will be going to lunch, and I'm so happy they are joining us. So let's have the questions for them. But in the meantime, let us really thank from the bottom of our heart the panel here, and on your behalf too, and those online. Well deserved. And hands down, the Coalition of Immokalee Workers and Fair Food Program and Worker-Driven Responsibility is one of the favorites, as you've seen, worldwide. But I am so happy because St. Thomas students, over the so many years, from the very early on in the early 2000s, we were rolling up like boycotting Wendy's, but we are with Burger King, McDonald's and others. At the beginning, we were only asking that they purchase 1 cent more for pound, I think, was it, or something like this? So we had all of these initiatives. So yes, we all can help. And thank you so very much for being here. It's such a pleasure and such an honor above all. And then you are a walking encyclopedia of helping labor and fair. Thank you for being here.